Good afternoon, ladies, gentlemen, dear friends, dear colleagues. A warm welcome to today's LiaNs seminar. I have the honor and pleasure to introduce today's event, but please let me specify that I'm not the main organizer of this seminar series. The main organizer who gave birth to the very idea of this seminar series is Professor Mireia Artigot from the University Pompeu Fabra, Barcelona, who is present among us today. So, LiaNs, legal issues arising from networks. These seminars touch upon different angles of important legal implications arising from digital networks. This seminar series started in May this year. This is our second seminar of the current academic year, but it's our fourth seminar in total. We will continue next month, in the next months, with seminars on diverse topics, including non-contractual liability, privacy, specifically the impact of the Data Governance Act on data pools. For
Aurelia, I think you are muted.
I'm sorry, it was my fault. I'm sorry, Aurelia, I was accepting somebody and I muted you. I apologize.
No problem. Right. So some topics of the future of the LiaNs seminar in the near future would include also the rights of consumers under price personalization schemes, and even the role of artificial intelligence in medicine. So a great variety of topics and a nice gender balance. So actually perfect gender balance. Albeit our only selection criteria is outstanding scientific quality for the speakers. And it's a great pleasure for me to introduce today's speaker, Professor Sofia Ranchordás. Sorry, Sofia, if I pronounce your last name less than perfectly. Incorrectly, sorry. Sofia is a full professor of public law and a Rosalind Franklin Fellow at the Faculty of Law of the University of Groningen in the Netherlands. And also, as from this fall, she is a professor of law, innovation, and sustainability at the LuISS University in Rome. And furthermore, she is also an affiliated fellow and a former resident fellow of the Information Society Project at Yale Law School. Professor Ranchordás' research focuses on how digital platforms, in particularly big tech, are reshaping citizen participation, the design of smart cities, and how technology is changing the constitutional and legal protection enjoyed by citizens. Today, she will present us her paper on empathy in the digital administrative state. Before leaving the floor to Sofia, we would like to take advantage of this moment to invite all of you to present your research in our seminar series at some point. If you like, feel free to send us an email. Dear Sofia, the floor is yours.
Thank you very much, Aurelia, for the kind presentation, also to Mireia for organizing this, as well as the whole team. I would like to share my screen, if that's okay. So for the past couple of years, I have been doing some research on two topics that interest me very much. One of them is bureaucracy, because like most people, I really don't like to fill in papers. I'm pretty bad at everything that has to do with them filling tests. And vulnerability. I'm interested in especially in how we can ensure that technology is not only a privilege for a few of us, but that has also it can be regarded as inclusive. The problem is that when we actually talk about vulnerability, we only talk about the problem. We also need to talk about the solution. And in my view, there is more that we can do to actually than actually just to regulate technology. I think we also need to talk about how technology impacts government, our relationship with government, and how we can make sure it is inclusive. And empathy comes here as one of the possible solutions for this. So this is part of the, I would say this is the first paper that hopefully will open the avenue to actually a book project that I will start working on next year on empathy and vulnerability in digital administrative states. So I think all of you know that the filling in tax is not fun, and it's very human to make mistakes. And many of us do make mistakes when filling in our taxes. And as this Atlantic article said, it's not a mistake. It's actually meant to be complicated, not because the government has a real interest in it, but just because there are actually softwares that can help us, which can be sold actually to make it more simple. But at the same time, this is not how it's supposed to be, because as citizens, we actually have the right to be able to fill in our taxes, to actually comply with our rights and duties without needing any kind of extra assistance. However, this is not exactly what happens. So the reality of most citizens is that it is very stressful to engage with government, to comply with all these transactions, and to engage with public authorities on a regular basis. However, government is with us from cradle to grave, and we have to deal with it. So while it is actually very human to have the struggles and to make mistakes, what we see is that until now, when we actually engage with government and we make mistakes, we also sometimes benefited from forgiveness of public authorities, that we were able to actually receive some leeway from human street level bureaucrats. However, the problem is that now when we make a mistake, we only interact with the software. We don't interact anymore with humans, or when we interact with humans, it's actually at a much later stage. So while the discussion right now has been in law technology for sure, has been very much focused on the automation of decision making as something that has to be avoided or it's forbidden. The problem is that even when we don't have fully automated decision making, we still have the problem that when we interact in the preliminary phase of decision making with software, we are already preparing the road to actually perdition in some cases, because we see that the information that is actually provided by citizens who do not have the ability to engage well with technology can be used against them. And unfortunately, we have seen this. So existing pockets of empathy to forgive this kind of small mistakes are disappearing in a state that is becoming increasingly digitized. And the idea that, of course, we have objection procedures and courts and everything that can help revise these mistakes is there, and it's theoretical. But in practice, we have seen that there are quite a lot of examples that show that when mistakes are made at an early stage, they can actually have quite a lot of impact on people's lives. The Dutch child care benefits affair is probably the most famous case to illustrate this. For the past decades, 26,000 families were actually regarded as fraudsters. Some of them were actually most of them had not committed any fraud. They made mistakes. They didn't know how to interact with technology, or didn't know how to interact with forms. And after these mistakes were made, they were basically captured because of the software that was used, that actually was able to find much more fraud than humans would because of the scale of the software's use. But also what we saw is that in this case, public authorities were very aggressive towards the citizens because they were supposed to be fraudsters for different reasons. Because they were part of ethnic minorities, because they had a past of drugs or unemployment or poverty. And all of this put them actually in a category, which made them more vulnerable to actually be caught in the system for two reasons. First, because they didn't have the literacy, the time, the mental capacity to fully engage with governments and actually do it in the proper way, and they made mistakes. But at the same time, once they actually had made these mistakes and they were caught in the system, it was also impossible for them to prove their position and show they actually had done nothing. So the child care benefit scandal, which actually led ultimately to the fall of the government early this year, shows that empathy was something that was not present at all in the system. All the citizens who had made mistakes, who were regarded as fraudsters, received no empathy from the state. They received no empathy from courts either. And actually now only 10 years later, the situation is being solved at a political level, but it's also calling for reforms when it comes to the judicial procedure to make sure that it doesn't repeat itself. Unfortunately, this is not the only case where technology has helped to enlarge the scale of exclusion, and where technology was this additional layer of bureaucracy, this additional layer that helped governments enforce the law in a so-called low-hanging fruit way, that is, against the citizens who cannot prove themselves right. There are other cases around the world, namely in the United States, with the Michigan integrated automated system. This system actually has a very high rate of mistakes. Actually, ultimately was the courts found that it was wrong 93% of the time, but the system was implausibly likely to find much more fraud, because every small mistake that was made by a citizen applying for unemployment benefits was regarded as fraud. The result was that also, just like in the Netherlands, thousands of citizens were regarded as fraudsters when applying for unemployment benefits, and they actually also were asked to return all the money they had received. So also, like in the Netherlands, technology enlarged the scale of the problem, because instead of helping governments to just find some patterns of mistakes and then ask for humans to actually analyze this properly, what happened was basically that the softwares were used to actually find mistakes, conclude that there was fraud, and there was really no human touch here to actually reinterpret the situation to see whether the citizens had indeed committed mistakes, had indeed the intent to actually defraud the government, or whether these were actually just situations where citizens did not know how to engage with government, could not do better, or did not know how to do better. So technology here was basically, in a way, an instrument of efficiency, because it helped find fraud, of course, because it was trying to find fraud, but at the same time, it was actually a technology with a very high rate of mistakes, because everything that was just a flaw in the system, that was basically an oversight, was immediately categorized as a mistake, as fraud. And then the humans evolved in the system, public authorities were not really able to mitigate these problems. They were not really able to actually introduce elements of empathy. And this also happened in other areas in the United States, namely with Medicaid in Idaho and also in Missouri. So this is a trend that we see growing. But we actually, despite all these scandals, these softwares continue to be used because they are highly efficient and they do provide for large savings. And this is problematic, because what we see is that citizens are increasingly becoming more vulnerable, and I think we all can be vulnerable at some point in our lives. And technology is just enlarges this vulnerability, especially when it is not actually doesn't have a counterpart of empathy on the other side from the side of street level bureaucrats. So how do I define empathy? At first sight, you might think that empathy is something which is not legal at all. It's just mainly like emotions, feeling sorry for someone. Well, it is in a way, but I don't embrace this definition. I look at empathy as a cognitive process, as an objective process, which can be part of a so-called evidence-based approach to law. So in this definition, empathy is regarded as a cognitive process which allows people to actually understand a situation from different perspectives. And this basically means that when we actually have an empathic system, we have a system where multiple perspectives are considered. And this is also what evidence-based lawmaking in justice is, to make sure that we have as much evidence, as many facts as possible, to ensure that we don't take biased positions. So this is this project on empathy is of course not only just a legal project. It's a project that actually draws upon literature from different sciences. I didn't mention here psychology, but obviously empathy is very much rooted in psychology, analysis, and neuroscience. And it really aims to try to bring together this idea that we need to have a better perception of empathy in the digital state. Because once we actually digitize government, once we digitize benefits, we need to understand whether people are able to comply with this new level of with this new bureaucratic system, which is digital and requires new digital skills, and how we actually are able to design it to make sure that this is as inclusive as possible and also forgiving when citizens commit mistakes. So having explained the context, in the remaining minutes that I have, I will try to address 3 points. So first of all is the challenges that are faced by vulnerable citizens. And this was already, of course, mentioned regarding the cases of child care benefit scandal and the Michigan case. where we actually already saw that sometimes citizens are caught in the web of the system. Secondly, I will talk about the general role of empathy in law, which is obviously something that has been regarded as quite controversial. And third, the most important part, of course, is to actually reflect upon how we implement empathy in democratic states and how we make sure that the empathy is not just, like vague words with that is very empty, but actually something that has a very concrete meaning that doesn't result in individualized justice. So the first point, of course, is the vulnerability that is actually an emergence from the digitization of government. The idea of digital government or the promise of digital government was, of course, to reduce bureaucracy, to make sure that transactions between governments and citizens will be faster, more efficient, effective. But the problem was that this promise, it was only partially delivered. In most cases, what happened was that bureaucracy just became digital. So an added layer of bureaucracy was added to what we already had. This is, for example, even more visible in systems like a German one, where you have to fill in your taxes online and you have to print them, sign them, and send them by mail. So in that sense, you still have systems where this is actually all double. But more importantly, the problem was that most countries did not actually create digital government from scratch. They actually created based on systems that were paper-based. So you fill in a system online just the same way you filled it on paper, which is, of course, obvious and logical, but at the same time, it means that we did not shift our mindset from the paper-based bureaucracy to the technological bureaucracy, which could be different. This is, for example, not the case of Estonia. So Estonia is the only country in the world that actually designed digital government from scratch. In Estonia, you don't have to actually fill in forms to apply for benefits. Everything's already pre-filled for you. And that means that you actually, instead of applying for benefits, you only object to not having received the right benefits. So the system is actually totally different to avoid the weight of bureaucracy. So it's a system which is much more citizen-friendly because it avoids this kind of interaction where you have to apply for numerous benefits and where you basically have always, as a citizen, the burden of applying for your rights. What we see is that digital government works quite well for certain citizens, but not for others. So digital government is mainly designed for the so-called average citizen. So the citizen that actually can engage with technology well, probably all of you here present in this talk. So for all of us who can use technology at a moderate to high level, we see that digital government is obviously very positive because it saves us time. For those who actually have proven disabilities and documented disabilities, new systems have been created. So documented disabilities mean that citizens who are blind or deaf or have any other kind of disability may receive assistance. There might be a special online form for people that need assistance in filling them in, for example, with dictation. And these are basically two categories that digital governments and administrative law know. So the average citizen and the disabled citizen. However, all these citizens that were trapped in the childcare benefit scandal and also in the Michigan scandal are citizens that do not fit in any of these categories. There were citizens who were struggling with poverty, who did have little time. Sometimes they had limited digital skills or literacy skills, but they were not disabled. So there are citizens who are vulnerable. Actually, we could even argue that vulnerability is a universal condition. At some point in our life, when a loved one dies, when something dramatic happens in our life, it could be that we all become vulnerable and we all become impaired in a certain way to engage with heavy bureaucracy. And when this happens, when we are in this element of vulnerability, government doesn't mean anything to us. They will not do anything to help us further. And basically, this is, in my view, the problematic point. Digital government is designed for average citizens and not for all the citizens. And in this gap that actually remains between these two categories, there are millions of citizens who cannot engage with technology on equal terms and who also will always be at disadvantage when they have to apply for benefits, when they have to actually rely on the state, but actually have to do it independently without any kind of assistance. And when we look at the Netherlands, but also other countries, the number of counters, of government counters, has been disappearing. There's barely any assistance when it comes to filling in forms, when it comes to interacting with government. We really live in a society of do-it-yourself government, which is, of course, for the average citizen, fantastic, but it's very inconvenient for the vulnerable citizen who will try to slowly try to engage with technology, might make many mistakes while doing so. And we see this, for example, also with the COVID vaccination, where there were actually quite a lot of citizens with low literacy who had a lot of trouble registering online and who prefer to call the number to schedule their vaccine. However, of course, while this worked quite well in the Netherlands, there were countries where the online system was much faster to reach than actually the phone system. And many citizens actually decided not to actually get vaccinated because it was too problematic, because they didn't trust the system. So then you see that even in the context of the pandemic, this kind of structure where vulnerable citizens are forgotten, when there is actually no real safety network for them, can also have negative repercussions. So having said this, the question is, of course, how we actually address this. How do we address citizens that actually, how do we make sure that also citizens who are vulnerable can still feel that they belong? In this context, I speak of empathy. And empathy is, of course, a concept about which many people have written in law. Is a concept that has been around for decades and also has been discussed in case law, both in civil law countries and mostly in common law countries. The first point I'd like to make is that I don't see empathy as only an emotional process. So it's not only the emotional process of feeling sorry for someone, forgiving someone as a matter of charity. Empathy is actually a system that actually makes us reflect upon the information that has been gathered and make sure that we actually are able to take into account all the different perspectives. So in a case law from the United States, we have seen that there have been judges that actually have referred to this idea that empathy should actually be about making sure that we have different perspectives on the table. This is, of course, problematic in administrative law systems, because administrative law systems, especially those influenced by French law, are systems that are designed to limit abuse, that limit human flaws of helping friends and family. So there are systems that are close to empathy, because if you are empathic, if you make exceptions, you are very likely to actually be prone to opening the door to abuses. So empathy, in a way, is a very elusive concept, because it is a concept that actually can make it difficult for law to be implemented, and therefore it needs to be carefully bound. However, when we look at the system of administrative law and at the public values that exist, we actually see that empathy is a key value of administrative law and of efficiency even. So, for example, when we look at the American case law on empathy, I could quote in this case the well-known DeShaney case, which was a case regarding the role of the county child protection authorities regarding the protection of a child, Joshua, who had endured years of domestic violence. And in this case, the child passed away because of the abuse of the father. And the court was actually asked to interpret whether the county, the social protection services, had actually done everything they should have to protect the child. The judge actually analyzed in this case not only the perspective of the judge, of the victim, the child, but also of the case of the situation of the county protection services, and whether they actually could have done better, whether they actually had enough information and could have saved the child. And in this case, we see that there is a line of case law involving social protection services, but also social welfare services and military services, namely the veterans, that actually try to look at these different perspectives and how empathy and how the existence of different perspectives can actually improve the quality of judicial lawmaking. So the idea here is basically not only to feel sorry for the victim, or feel sorry for the citizen, but actually try to improve the quality of case law by ensuring that all relevant perspectives are considered. So compassion can help, of course, judges understand with fully objectify adjudication, because it really helps understand what is really at stake. And also not only what's really at stake for citizens, but also for public authorities, in the sense that the two perspectives can be better understood. And what we see right now, in many cases, also in civil law countries, is that when public authorities make mistakes, they can easily correct them. However, when citizens make mistakes, even though on paper there are some mechanisms for the correction of mistakes, like, for example, you send the petition to the wrong courts, in reality, the mistakes that are made by citizens are not as well protected and forgiven as the ones made by public authorities. So in this situation, I think it's important to make a separation between law in the books and law in reality, because even systems that are supposed to be systems to protect the citizen against the state are systems that are not very empathic because of this fear that administrative law seems to have of opening the door to abuses. So empathy is, on the one hand, a public service value, which is present in public administration and public policy literature. And it is presented as the idea of supporting others, of being open-minded, but it coexists with other values like efficiency or accountability. So in a way, it should mean that citizens' needs should be taken into account, but of course they have been taken into account with regard to other values, such as, of course, accountability and transparency. But if we are to actually implement empathy in the administrative law and make sure that empathy can be used to protect citizens vis-a-vis digital government, we actually need to understand how this actually is implemented. So as I've mentioned, there is a system of loss of empathy because softwares and algorithms don't see the color of poverty. They don't see how people actually have, struggle with bureaucracy, how people struggle with engaging with technology, and basically the law is applied almost blindly. And this was like what happened also in the Dutch childcare benefits scandal and also in the Michigan scandal. When we actually are going to change the system, if we are to actually introduce empathy in the system, we actually need to do that. This is what I argue in my paper at 2 levels. First, we should do it ex ante, and which means basically that empathy should not only just be taken into account when the harm is done, but actually before that. So basically what I argue in my article is that to understand a certain legal position and to understand the position of vulnerable citizens, we should actually do that even before something is automated or something is digitized. Even before then, we need to actually ask ourselves, does everything need to be digital? Do we have alternatives for the digitization of services? Can we actually make sure that this is actually inclusive and accessible to everyone, even people that only have the minimum literacy? And unfortunately, this actually is not always taken into account. So in a way, this anti-empathy is a way of making sure that digital government is not only designed for the average citizen, but it's actually designed for every single citizen, also for vulnerable citizens or for any individual that finds themselves in a vulnerable position. So in practice, what does this mean? It means, first of all, to rethink our digital strategy and make sure that we have the right to meaningful contact with the government. So this plea for more human digital government basically does not mean that we're not going to have digital tools. I mean, this is impossible. Digital technology is extremely efficient and it should be maintained. But it is important that we balance costs and benefits of the digital objective state, especially regarding social welfare benefits, because these are basically the areas where citizens are most vulnerable. So in a way, we see that there is already like an attempt to rethink this and make sure that that there are limits. And this is also visible in the AI regulation proposal, for example, certain bans of high-risk services. But the thing is, we actually should actually delve further into this approach to AI when desirable, when possible, responsible, ethical. Because the thing is, it is possible that when we automate social welfare policies, that we actually might be going too far in certain cases if we don't introduce enough empathy in the system. So in this case, the argument is basically that if we don't have this ex-ante assessment, especially regarding certain benefits, we might be actually putting at stake the legitimacy of government and the protection of certain public values. From the design perspective, this ex-ante approach also means that the design of government should be done in a different way, in a way that is more accessible, more inclusive, that is perhaps less dependent on private companies that often offer the softwares. And also, this could also mean that that we actually should adopt a system that is closer to the Estonian one, which basically means that that the benefits are not always to be applied for in the way that they are right now, but there is an inversion of the burden of proof that allows citizens to actually be more passive regarding certain benefits, certain certain rights, and instead they can actually be recipients of services. So basically, this would mean a shift of the whole system, which of course might not be totally possible, but it's an idea to be considered. A less radical idea that actually has been also proposed in this context comes actually from the research of Hilary Cotton, who argues that social welfare systems should actually be profoundly reformed, but actually to establish a human connection with citizens. So this basically this proposal is that instead of having all this elimination of government counters, we should actually, instead of creating distance, increase the proximity between citizens and governments. And this basically means improving the communication between groups affected by poverty and caseworkers. Inclusive communication design are therefore part of this ex-ante approach, including a greater human touch in technology. But this is, of course, not enough. Mistakes will still be made, and this means basically that we still need to have an ex-post approach to administrative adjudication, that is, to decision-making. What we actually see is that there are different policies that we can actually, and laws we can already draw some inspiration from. So, for example, in France, there is already for a couple of years something called the right to make a mistake. And the right to make a mistake has been included in the law. And it allows actually citizens to make one mistake in their lives when engaging with government, namely when filling in their taxes. This is a systematic approach. In the Netherlands, we also, of course, have the possibility to actually forgive mistakes, but it's much less systematic than in France. And the system of forgiving first-time mistakes is interesting because it creates, it is not, of course, not a panacea, but it is a way of showing, of conveying some empathy towards citizens, but also showing public authorities that there should still be leeway for forgiveness in the digital age. That this real for empathy, forgiveness is not incompatible with the idea of a strict administrative law. Secondly, another point of ex-post empathy comes, of course, with evidence-based justice. And that means basically that empathy should also mean that judges should not always trust that public authorities will fully review a decision at the stage of objections. But in this kind of cases where technology was involved, it might be important that judges go a little bit further than actually what they actually do now and try to gather multiple perspectives and more information than they do. So in paper, again, this is, of course, like in Dutch administrative law, this is something that already exists, so that people could claim, yes, but the judge can already do it. But the reality is that judges don't always do this. And this was quite clear in the Dutch child care benefit scandal, where judges actually did not fully review decisions, where not in many cases, new perspectives were brought into the table. And more importantly, where judges did not ask themselves where the citizens could have done better, considering their conditions. So in this case, what empathy ex-post also aims to trigger is empathy in a broader sense, in the sense that there should be procedural mechanisms, and this is something I hope to be able to develop in a book. But there should be duties to actually try to understand the position of citizens, to create frameworks for forgiveness, and to convey empathy within an evidence-based context. So this is not about just creating exceptions, because this would not serve material justice, but it's about creating and rethinking our frameworks to make sure that vulnerable citizens are also equally protected when it comes to procedure. So to conclude, I think the main message from the paper that I have shared with you is basically that empathy in digital states is thus about redesigning, on the one hand, digital governments and automation strategies to make sure that communication is more inclusive, that interaction with government is meaningful. But at the same time, it is also about not trusting blindly technology and making sure that we actually continue to conduct meaningful investigations of the individual situation of citizens, but also that we understand that a bureaucratic system is full of contradictions, of opacity, and that citizens very often cannot fully comply with it, because especially when it comes to social welfare benefits, what we see is that empathy really requires human intervention and humane assessments, but also requires us as lawyers to really see that in many cases citizens cannot do actually much more than they do, because very often only human decision makers can actually see it and actually see. What we see is that in a digital operative state, we cannot have decision making that is barren of emotion, that is inflexible, and that is unwilling to listen to concern. So it's not about bending the rules. I don't think empathy is about bending the rules, but it's actually mostly about creating a system or thinking a system so that there is a legal framework where citizens feel seen and heard, even with the growth of technology. Thank you.
Thank you very much, Sofia, for this very interesting, fascinating, and moving presentation, also emotionally moving presentation. I'm sure that there will be questions, comments, and a lively discussion. So it's now my pleasure to open the floor for comments and questions. Please use either the raise hands button or the chat. I see a raised hand by Evert Neppelenbroek. Evert.
Thank you for your interesting presentation. Normally you're some kind of neighbor, and I haven't seen you in a while, so nice to see you again. I've got 3 points to make, and I'll be brief. The first one is just checking whether I understood correctly, because you handle a lot of things. Is it correct that you first of all say about making the decision, and then communicating the decision, and then the education surrounding the decision? Those are all aspects that you brought to the table. I think that's a very broad perspective, and I think like for the first part, there could be a lot of wisdom drawn from the long discussions that already have taken place within law and informatics. That's a very old discussion, really. So I wonder whether you take that into account. The second point I like to make, interesting point, I think, is that in literature there has been a lot written about so-called negative feedback loops. Like Cathy O'Neill in Weapons of Mass Destruction says, when you are in a vulnerable decision, when you're preyed upon, so to speak, by automated decision making, you can get in an even worse and worse and worse position. That might be an interesting thing to look at. And the third thing I want to stress is this really only a government problem, or is this a problem of any organization having a big bureaucracy, such as banks and insurance companies? I have a lot to ask, but I hope this was short enough.
Shall I answer? Yeah, sure. Evert, good to see you. Ideally, we were neighbors in Groningen. So yeah, thank you very much for the points. So I'll start actually with the last one on bureaucracy. Absolutely. I mean, this is something that exists everywhere. Actually, I think any large company, any large institution struggles with this. Any large institution where there are procedures that have to be, have to be followed, is not flexible enough to deviations. So in that sense, you're absolutely right. Also, a bank, any private company experience this, but of course, the problem is that in private law you have a choice. In principle, you should have a choice. You have a choice to go to another bank. You have a choice to work for another employer. Well, as a citizen, you only have one provider of services. You can only get your benefits from that very state. you cannot get it from an alternative state. There is only one provider of services, which makes you extremely vulnerable. And that is basically the reason why. Of course, I'm a public lawyer, so in that sense, I mean, that's what interests me. But the truth is that the fact that we have one sole provider of services makes us much more vulnerable to this kind of problem. So in that sense, and besides that, it is not only just like a private law contract. It is that we have constitutional rights to many of these services. So it is that our right as citizens to actually use Social Security, for example. So in that sense, it is the different constitutional dimension. Regarding the negative feedback loops, you're right. Indeed, it is something that has been very well documented in the literature, especially American literature. I did not develop this further because I think this is already very well explored in literature. And what interests me more is actually not only just the element of the negative feedback loops, but actually like more the engagement with government as a whole. So actually the step that actually comes before that. Regarding the first point you made on making decisions and law informatics, this is true. There is indeed a more traditional literature on law informatics that has delved into this point. Actually, also this idea of paper-based technology and actually the origins of digital governments. I did not deal with this in this paper because I wrote a paper last year that actually goes more into this direction of law informatics. But I do acknowledge that this is also a very important strand of scholarship. So thank you very much for mentioning it.
Thank you. I see Mireia as the next person asking questions, and then after Mireia, Matthijs. First, Mireia.
Thank you very much, Sofia, first of all, for accepting the invitation, and second of all, for the seminar. And I have two questions, or they are probably related to each other. The first one is, like, the title of your presentation focuses on the digital administrative state. And I feel that the content of your presentation is applicable to any administrative proceeding, and that perhaps digital and algorithmic decisions might have worsened this situation, but not necessarily created it. And the second one, and I would like your view on that. And the second one related to this is, let's say, I really agree with you that this idea of empathy, like, in fact, I think it's a mechanism that reinforces legitimacy at the same time, right? And for example, what happens when the mistake, these mistakes that you were explaining are not committed by the citizen, but they are committed by the state, and it's the citizen who needs to fix it, and it's the state putting the citizen in a vulnerable position. And we have now a fantastic example here where we just have, like, currently we have like this tax agency issuing this collection for CO2 taxes for cars ownership, and like there's around 3,000 people who don't own the cars anymore, the vehicles anymore, for which they are intending to collect the tax. So they are telling them, okay, you can provide a document, but if not, the first thing you need to do is pay for this tax, which of course it's very questionable. So they are trying to amend this, but I mean, it's very rigid. So thank you very much.
Yeah, absolutely. So yeah, the title is digital administrative state, but this is mostly applicable to digital decision-making in general, so adjudication. So most adjudication, I would say, if we are going to be very precise about administrative law, adjudication. So the thing is, I mean, you're right that digital technology does not create a problem, but it worsened to an extent, to a massive scale. So for example, the Dutch childcare benefit scandal, but also the Michigan case, would not have had the proportions that they did if technology did not exist, because they would have needed, government would have needed like 10,000 of citizens or of street level bureaucrats to investigate everyone's life to that extent. So in that sense, it definitely does not create a problem, but it expanded. And it expanded because suddenly you can actually just not, I mean, of course, before, if you like, I mean, street level bureaucrats are not perfect either. They could probably look at your face and say, I don't like your face, and also, like, you know, start like a little war against you, but it was an individual case. And here, the software that we use enabled like this mass scale a witch hunt of poor people. So in that sense, it really it doesn't create a problem, but it worsens it to an extent that is that humans could never do. So that is definitely a big problem, I would say. And for example, in the Netherlands, there were more than 1,000 children that actually removed from their homes because of this. What actually was 1,100 children, 1,115 children. Basically, I mean, the parents have actually put them at the child care, received benefits, and then they were regarded as fraudsters. They had nothing, and then because they actually put their children in the kindergarten and allegedly not pay for it, ultimately they lost their children. This is totally disproportionate, but this is what happens. And I mean, this would have never happened to 1,100 children. So in that sense, it is something that it's really big in a way. So empathy here is a way of course, empathy. I mean, I also mentioned in the paper that empathy does not have to be only introduced by humans in the procedure. We can also introduce empathy in digital systems. So actually, nowadays AI can be more empathic than humans, because apparently this new generation of humans here actually is less empathic than we were, and the generation was. So actually, our human race is evolving in a way that each generation is becoming less and less empathic, which is interesting to see. So there is the potential that we actually can redesign the AI systems to be more empathic. So there is also that possibility, obviously, but we still are a little bit far away from that. So we still need to actually combine human and technological ways of empathizing with citizens. And that is something that will definitely contribute to the legitimacy of governments. Last point you made, if I'm not forgetting anything, I mean, I think when the state makes mistakes, this is even more serious, obviously. For example, in the case of Michigan, unemployment benefits, mistakes were all made by the state, actually. And still what happens is, and maybe perhaps because courts in the US were more active, this did not last a decade like in the Netherlands. This was actually solved within 2 years. So it's also important to say that courts can do actually better than actually the Dutch ones did, because in the US, they actually definitely acted faster. But the thing is that the systems in general in Europe are very much favorable towards helping public authorities fix their mistakes. So you actually, if a public authority has made a mistake, a case gets sent back to the public authority to be corrected. And then you already see that the system privileges very much the mistakes made by governments, and actually is always very empathic towards mistakes made by citizens, because citizens are always the abusers, which is, there is this, this perspective of adversarial relationship between citizens and governments. And this is basically, unfortunately, something that is very much present also in the mentality of citizens that actually have to deal with governments. I'm not going to delve much further on this, but there is a very interesting book by Inze Koch on the dynamics of the adversarial state, and how actually the way in which, if a citizen makes a mistake, he's a fraudster, but when the government makes a mistake, it's okay. These dynamics actually mean that citizens start having so-called government anxiety, and start fearing any kind of engagement with government, and this explains very much why some citizens actually do not want to engage with government, do not want to get vaccinated, and do not trust government ultimately.
Thank you very much, Sofia. And now I see Mateus, and then a question by Felipe Roquete via the chat. So first, Mateus.
Yes, thank you, Sofia. It was really great, and I really like the paper, and let's say this whole direction you took in your research. I think it's really fascinating, and it's really enlightening, not only in terms of public law, but also in terms of private law, consumer law, and all the other spheres of the legal system that are somehow affected by new technology and algorithms. And my question to your paper, and it's mostly the question for understanding, because I was curious when I was listening to you how you connect those spheres. So my question is about how you see the link between what you have been doing in the paper with this whole theoretical output in the sphere of personalized law, personalization of justice, and so far. So you slightly referred to this question whether what we are talking about relates or does not relate to this tailor-made justice for every citizen separately. But I'm interested in this question in a slightly broader perspective, because some of the problems you've been discussing, for example, the question of forgiveness, and some like differentiated treatment of, for example, some perpetrators of some petty crimes, depending on the age and depending on whether it's the first time or the repetitive practice, repetitive behavior. It sounds like something that can be somehow fit into this scheme of personalized law or personalized justice. And so my first question is, how do you see the relationship between those two spheres theoretically? So do you think that personalized law debate has any bearing on what you are doing? And if so, do you think that your research can somehow be linked to the debate? And secondly, on a more, I would say, down to the earth perspective ground, do you think that some of the practical problems you've been talking about can be now or could possibly be in the future regarding the expected development or the algorithmic decision making can be resolved through like more precise, better tailored algorithms that can simply be more sensitive, however we would frame the sensitivity, to individual needs and the individual characteristics of the citizens at stake. Thanks.
Thank you very much, Matthias. These questions are absolutely brilliant, and this is actually something that I really hope I can actually develop a bit better in the book on this, because it's I would say this is actually like a whole different chapter in a way, but it's very much connected. So I do see the connection. I think the only thing that I think we have to take into account is that most of the work that has been done on personalization of justice, on like if I think of the Chicago special issue on personalized law, has been focused on consumer law, right, on private law. And as I said, there is then a difference between private law and public law, because while you can personalize, you can discriminate prices in public law, in private law, you cannot do that in public law, right? So in that sense, that's why we have to be very careful when we translate this personalized dimension of law, which can have, of course, great benefits, and we want to get those benefits. We don't want the discrimination part. We want the benefits. So what actually we have to be careful is exactly this translation between the private law part, which especially the part where we discriminate, and the public law. So I would say that I do see the connection, and I do think that it can contribute to actually redesign the system, especially now I will actually connect this question to the question that was raised also in the chat. So we can actually personalize law for the good if we actually introduce empathy by design. So if we introduce empathy by design in the system, it is possible to personalize law in a good way. And for example, I know that the Dutch government has been working with algorithms that actually try to find whether citizens are at risk of becoming bankrupt, of not being able to comply with their debts, for example. And basically, this is something that would be also a way of personalizing assistance and law and also justice in a way, but not in a way that you discriminate citizens, but in a way that you actually assist and nudge them and be more paternalistic about it. So that's how I would connect it. But again, this is I would say this is a chapter, a topic in itself that I still have to delve a bit much into, but I'm happy to continue our conversations, of course.
Sure, thank you so much. There's like just Aurelia, one more sentence to add. There is a newly published book by Henri Ben-Shahar and Ariel Porat on the personalized law. I can just send in the chat the link. And there are some parts of this book that try to somehow depart from like this purely like private law focused discussion on personalization. So maybe it might be interesting for you, but this is just a...
Thank you. I didn't know I had published a book. Thank you very much. I'll definitely check it. Thank you.
Yeah, thanks.
Great, thanks. Then I see a question by Felipe Roqueta via the chat.
I think I just answered it when
yes. Sorry, sorry. All right, then I don't see any other questions or raised hands, or let me look around. Perhaps anybody who would like to say a closing word on this brilliant paper and brilliant presentation and discussion. Well, I really enjoyed both the paper and the discussion. So really well done, and it's really great.
Thank you for having me.
You're most welcome. All right, then if the discussion is concluded, then I would like, in the name of all organizers of this seminar series, to thank our distinguished speaker, Professor Ranchordás, a lot for her presentation, and to thank everybody for their nice contributions to the discussion and for their participation. And hope to see you soon, next month, or when is the next seminar due to take place. Let me take a look at the schedule. 1st of December, Dr. Ana Maria Correa from the University of Leuven, I see on the schedule. Right. Okay. Thank you very much. Bye-bye. Have a nice evening.
Thank you. Bye.
Bye.
Take care. Bye.
Bye.